Yes, there we are again. Today we're going to talk about competition law and next week as well. What is it about? Basically, you see it already here on the first pictures. We see some businessmen, usually, basically on all the pictures we see businessmen. Also, funny that we only see men. Sorry for that, ladies, but also reality dictates to us that very often these board people are men. Maybe that's one of the reasons why they behave so badly. But what we're talking about essentially in this week and next week is about illegal forms of doing business. Um, Basically, we live in a free market economy. I don't think that needs any further explanation. We live in a capitalist system in Europe and in all the member states, and it basically means that there is free competition between companies. But there needs to be an element of fairness to this competition. And companies have the inclination not to be fair. And so, just as normal people, legal persons, companies are also lazy. After all, they're being run by normal persons, and and of course there are shareholders also who want good results. So there's a lot of, let's say, temptation not to play according to the rules and to play unfairly. This can have all kinds of forms, being unfair in business. And the two forms that we're going to focus on in these lectures this week and next week are cartels and monopolies. So cartels is basically when you group together with some other companies and you secretly make deals in order yeah, to have less competition. So it's an anti-competitive practice. You say, for example, we divide the markets, you take France, I take Germany, you take Spain, whatever, and we don't bother each other in those markets. And this is not good for the free, real competition. So this is one example. And then the monopoly example is, of course, you can think of the game Monopoly. It's about one big, huge player that is so powerful that it can actually um, behave in a non-competitive way, and for example raise the prices to extreme levels. As it has no competition, it can do that. So that's also unfair, deemed unfair. So these pictures you see here, the man sitting there with the paper, and these hands sort of dealing in gold and euros or whatever it is, they depict what the problem is with these illegal forms of um, competition. All right. The text on the second picture, it's not really there, but it says something. Why shouldn't we promote teamwork? And then the other person on the table said, well, the government calls it antitrust. So that's of course always the big problem. Whereas the transition from working together with other companies in a team to being unfair and really forming a cartel, and because it's not in principle illegal to work together with other companies. And so that's important to understand. You can work together. There are many companies that work together. But it's not illegal to work together. It becomes illegal if you work together in a way that harms the consumers in the end. But we'll explain that in the class. So, today on the menu, we have a short introduction. I already started the introduction. Then we go to the cartels that are regulated, so laid down in Article 101. We go into depth in all the elements of the article, and then we go to the exceptions. You know the system by now. We always have a rule, and then we have exceptions, and finally we go to the so-called leniency policy. Alright, the introduction to EU competition policy. So we see the boxer here, showing the element of competition between companies. So what is EU competition policy all about? It's about regulating activities of commercial undertakings, so usually companies, in order to curb the excesses of the free market. Yeah? It aims to ensure that a variety of the same or similar products of different sellers are available in competition with each other. So that's of course all in the vein of capitalism. There should be competition, and that's why when you go to the supermarket you see thousands of brands for each and every product these days. If you go to Albert Heijn, for example, so a variety of products, similar products, you can buy, I don't know, 20,000 different cookies. That is the idea that this is possible under this system. Um, Why is the EU responsible for competition policy? That is, of course, because there's one European market. Yeah. So that on that European market, the EU, the Commission, European Commission, is the watchdog, is the competition policy watchdog. There are also authorities in all the member states, national authorities. Yeah. So if there's a competition issue within the member state, then the national authority is responsible. But if it's over the borders of the EU in other EU countries, then it becomes an EU issue. The rules are designed to prevent agreements which fix prices or conditions of supply and or carve up territories to prevent abuses of market power. So these are some examples that we'll go into separately in a moment. Yeah, but basically the idea is that there should not be any illegal form of collaboration to harm the consumers, us. All right, so as I said, there are four main areas, the cartels and the abuse of a dominant position, those are the monopolies. And then we also have the merger controls and state aid. And those last two, merger control and state aid, we do not deal with in this course. But it's important to know that they are there. Yeah, so if two big companies want to get together and form a new company, then the European Commission needs to approve that. Yeah, it needs to check whether that new company would not become too powerful. And state aid is, of course, a situation where member states give money to companies. For example, football clubs. So, for example, they buy the stadium of a football club and all these millions go to the club. That's a form of state aid. Now the question is then, is that legal or illegal? So very interesting, but not for us to cover under this course. A very important regulation is Regulation 1/2003. There you can find all the key information on what the European Commission can do in order to enforce the rules on competition. So please look it up and browse through it to get a feel of what the possibilities are for the European Commission. Fines, well, one rule that you will find in that regulation is that fines can go up to 10% of the total worldwide turnover of the company. Yeah. So basically, the European Commission can give huge fines, and they do, and we'll give some examples of that later on. Now, important to also know that the general economic climate does influence the Commission, so it's also in some ways a political process. And so when there's a very weak economy, the European Commission might be more eager to allow mergers than when the economic climate is weak. Let's focus now on the cartels. So the basic article for cartels is Article 101 of the TFEU. Let's start with a small example. I would recommend you go to Google and look up some examples of cartels, the European Commission, and you can type, for example, European Commission cartels, examples, press releases, something like that. You will find more examples. This is one that I decided to include. It's from this year, 2017, and it's a huge fine. A total of 76 million euros was fined to an air freight cartel. This is an older case already from some years ago. But this is was again adjudicated, was again ruled on. A huge fine was imposed on Air France, British Airways, KLM, Air France, KLM, British Airways, and some others. And basically, what these flight companies, did was that they artificially overpriced the transport of goods. And so they sat together, they made secret deals that they would increase the prices together. And that's how they made a lot of extra money. Now this is to give you an idea of what we're talking about. Some other general information before we zoom into the article. This is from the year report of the European Commission. You can find it online. And you can see over the years how much money was fined on cartels. Of course, it's not 3,727 euros in 2016, but it's 3 billion. Yeah. So 2016 was a good year, you could say, for the European Commission. 2017 is small, but that's because we are not at the end of the year yet. Although you wonder what happened in 2015. I actually don't know, but well, probably they prepared a lot of cases that were actually then finally done in 2016. That's why 2016 is so incredibly high, probably. Good. Now we're going to do some very nitty-gritty picking of the article, explaining the article. And this is a very important skill that you hopefully have already developed by now. And this is also what you need to show at the exam, is that you can analyze an article. Yeah. Article 101 is a very good example of an article that you can really analyze each element of the article and explain what it means. So this is what you find in the article, the key elements. So it's not literally the text, but all of this is in the article. So it's about a form of agreement between undertakings, decisions by associations of undertakings, and concerted practices, which have the object or effect to restrict competition, and which may affect trade between member states. Yeah. Now, at first glance, or when you first read this, this is very dazzling. Probably you have no idea what it means. That's okay. That's normal. And now you need to zoom in, do some close reading, and really, explain it. And you can do that by, well, of course, viewing this video, but also reading and using case law. So let's start with the first elements. So we're talking about agreements. And that was, if we look back here, form of agreement. Yeah, we start with what is an agreement. Now, it's important to know that the shape or the form of the agreement does not matter. Yeah, so it can be minutes of a meeting, or it can be even a handwritten letter, or it can be even oral agreements, so things that were discussed but not put on paper. So that's important to know. So you can already, in the legal sense, agree or sort of establish that there is an agreement without the form being important. So it doesn't have to be an official document that reads agreement. In general, in law, this is usually the case, by the way. So this might also be useful information for yourself. If you have, for example, an oral agreement with someone who rents you a room, this is also, in the legal sense, a binding agreement. Of course, it's difficult to prove that you have it. That's a different problem, but in principle, yes, that's an agreement. The second element is undertakings. Now, this is a dangerous word. We've used it before, and you know it from Dassonville, for example. I think it was in Dassonville, I'm not sure actually now, but anyway, the word undertaking is used more often in other articles of the TFEU, and it basically usually refers to companies. Yeah, it's broader than that. As you can see here, an undertaking embraces any entity carrying on an economic activity regardless of its legal status or the way it is financed. Yeah, so you see it's a broader definition than just simple companies, but 99% of the time we're talking about companies. Yeah. But important to know that it can also be other forms, other entities out there, yeah, as long as they comply with this definition. The next point is decisions by associations of undertakings. So you can think of, for example, of trade associations here, or representatives of, let's say, the agricultural sector in the Netherlands. Yeah, so those are associations of undertakings. All these agricultural producers, they are under this association that unites them and that represents them. This can also be an entity that can be involved in a cartel. Then the next element is concerted practice. Now, this is basically in the article to create an umbrella, or rather a safety net. An umbrella would be here, a safety net for situations that you cannot properly prove that there was an agreement. Yeah, an agreement requires, of course, that there's some sort of will on both sides or all sides of the cartel to behave in a certain way. But yeah, this is basically a safety net for situations where that's difficult to prove in that strict manner. But you do have other indications that there is indeed a practice that is concerted, so that is coordinated. Two cases that are important in this respect, the dyestuffs case and the sugar cartel case. The dyestuffs case was about companies that were active in the field of dyestuffs, so coloring, and they all elevated their prices by, I believe, 10 to 15% or so in a very short time span, basically copying each other. That's called parallel behavior in the market. And there were also some telexes involved there where this coordination took place. So that indicates a concerted practice. The elements that you see on the slide here are from the sugar cartel case. So covers informal forms of collusion, can be seen as safety net, as I said before, for situations that cannot be properly described as agreements. So the 3 points that we see here on the slide are on the sugar cartel case. So there must be a form of coordination or practical cooperation. It needs to be achieved through direct or indirect contact. And the aim must be to remove in advance any uncertainty as to the future conduct of competitors. So this is of course a very important element. Yeah. So remove in advance any uncertainty as to the future conduct of competitors. Yeah? So you need to somehow signal to each other in a clear way that you're safe to also increase your prices. And this can have all kinds of forms. And there can be all kinds of implicit ways in which you can communicate that to your competitors. So for example, in newspaper articles, in interviews that you give, where you hint these things in a very clear way, and so on. So I admit this is vague, and it is indeed vague, but of course we need these kind of, the treaty needs these kind of provisions because companies are of course very smart in knowing how to sidetrack these agreements and make it difficult for the Commission to approve them. Yeah, that's their primary objective. They would never just sit together in a boardroom and draft up an agreement and hereby we agree to fix prices, we're going to elevate the prices by 5% in next year, la 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 la. And that is very unlikely because these companies also know that they can be fined by the Commission. Good. Then we go to what forms of illegal behavior we can discern. Now, these are some examples. This is not a limited list of examples, so you might find other examples that still qualify under Article 101. But in the treaty, we find these examples to make it clear what we're actually talking about. Price fixing is, of course, the clearest one. And we're going to elevate the prices, make more money, easy. Think of the air freight cartel, great. Limit or control production, this can be an agreement that has the same effect, the prices will go up. If you have less, you produce less and the demand stays the same, then the price will go up. Yeah. Market sharing, you take France, I take Germany, and so on. Applying the similar conditions to equivalent transactions, so you cannot have with one party or certain parties that you supply the goods for a certain price and under certain conditions, and for a different party have all kinds of additional requirements. That's not allowed. And tying, and that's the last example that we will discuss in class. It's basically also about tying in services or products that are not necessarily connected to the initial service that you provide. And for example, you provide tires for cars, and that's your product, and you say you should buy these tires with a tied-in obligation to also buy our whatever, you name it, hubcaps. Yeah, so that's also illegal. Then we go to the next element, object or effect. And this is again a piece of case law you have to use here, constant grundig. Grundig constant I usually say. So the article says that when the agreement has the object of restricting competition, there's no need to assess if the agreement actually does have restrictive effects on competition in practice. This is not in the article. This is from Grundig constant, yeah? So in the article it says which has the object or effect to, And what it means is that if the agreement has the clear object, so the aim to restrict competition, you don't even need to prove that it actually does restrict competition. And this is, of course, a major windfall for the Commission, because it saves the Commission a huge pile of work to actually prove that there are anti-competitive results, effects from certain agreements. This was decided in Gruner-Constant case that you can find, that we will discuss in more depth in the classroom and also in the seminars. Very important point. Then the last element, which may affect trade between member states. This element is in the article because, as I said before, we have to have situations that actually have to do with different EU member states. If the anti-competitive effects are only within one member state and don't have an EU-wide, or not EU-wide, but an EU transborder effect, then there is a possibility to say that it does not require with this component of the article. Although there have been cases where purely national cartels were also taken up by the Commission. Yeah, so it's a bit a gray area when it falls clearly to the national authorities or to the Commission. Some examples: 2 undertakings established in 2 different member states, 2 undertakings established in 1 member state, or 2 undertakings established outside of the EU. That is one that we have not talked about before, but this is always a trick question that we sometimes decide to put into the exam, not always, is what if a Japanese company, an American company, and a South African company have an agreement to artificially raise prices or whatever that are active on the European markets? Can the European Commission actually do something against this? Because these companies are not EU companies. And the answer to that is, if you read the article carefully and you analyze each element, then you see nowhere that there's a requirement that the companies need to be European companies. Yeah, so it's about having effect on the EU market, and if there's an effect on the EU market, then they can also be held accountable. Then we go to the exceptions. So are cartels, or is collaboration always illegal? No. First of all, we have the exceptions of the so-called de minimis notice. This was a notice issued by the Commission, where it said that if the market share of the total cartel in so-called horizontal agreements, so those are agreements between companies that work in the same layer, the same level of the production chain, for example, Bavaria, Grolsch, Heineken, they work on the same level, they're beer producers. Those are horizontal agreements. If the market share is less than 10%, which is not likely with these companies, by the way, then it's not a case that the Commission will look into, because the impact is too small on competition. If we talk about vertical agreements, to stay with the beers, Heineken and, let's say, Bars of the Hague, that's of course a very small case, not a good example, but anyway, you get the idea. And so a producing company to a retailer or persons that sell the beer in the actual market, that's vertical agreement. Then if it's under 15%, then there's also not a case for the Commission. So those are the de minimis exceptions. And then we also have in the article in section 3, paragraph 3, we have a very clear, I think straightforward exception. It says that if the agreements or the concerted practice contributes to improving the production or distribution of goods, or it promotes technical or economic progress, and it allows consumers to obtain a fair share of the benefit, and these agreements are indispensable and do not lead to elimination of competitors in the market, on those 3 cumulative conditions, so they need to all be fulfilled. Under those conditions, an agreement is allowed. Yeah, so that also explains these agreements between companies where they set up a joint research and development cooperation, for example, because it improves technical economic progress, it allows the consumers the benefits because it becomes cheaper. They have scale advantages, for example, and they unite their knowledge. And it does not lead to elimination of competitors, so they don't push out smaller companies by doing this, then yes, it's allowed. It's a logical exception, I would say. And then finally, a few words on leniency to close off this, this video. Leniency is a policy that has been proven to be very successful by the European Commission. Basically, it means that companies can go to the Commission and, like whistleblowers almost, but not really because they're usually involved, they can tell the Commission that they are part of a cartel. Yeah. So let's take the air freight carriers. There was a company, I think it was Lufthansa if I'm not mistaken, but one of the air freight carriers actually went to the Commission with a huge pile of evidence saying we are in this cartel, we've been in this cartel for years, and we want to denounce it. And you can also call it backstabbing if you like. And if this company does that, it can get full immunity or a significant reduction in penalties from the European Commission. So it's a very smart system that the European Union uses, and it has been a very successful policy also. And so many companies, after some years, after having benefited for years from these cartels, they go to the Commission and they denounce the cartel, provide information, provide proof, which is of course also very convenient for the Commission, and then in exchange it doesn't get fined, or it gets a lower fine. So this is important to know that this policy exists. Good, that's it for this week. Next week is already the last video lecture, and then we're going to focus on monopolies or abuse of dominant position, and yeah, well, looking forward to that. Bye bye.